I'm sorry, but I don't want to be an emperor. That's not my business. In this world, there's room for everyone, and the good earth is rich and can provide for everyone. The way of life can be free and beautiful, but we have lost the way. Greed has poisoned men's souls, has barricaded the world with hate. We think too much and feel too little. We think too much and feel too little. More than machinery, we need humanity. More than cleverness, we need kindness. Without these qualities, life will be violent, and all will be lost. All will be lost. Do not despair. The hate of men will pass, and dictators die. Dictators die. And the power they took from the people will return to the people. Will return to the people. Let us all unite. Let us fight for a new world, to do away with greed. Now let us fight to free the world, to fulfill that promise. Let us all unite.
Nation Radio Show. I'm Clint. My guest today on this April 10th of 2014, a Thursday, of course. And on Thursdays, we have our usual guest, Freeman Burt from Colorado. OnlyFreemen.com. OnlyFreemen.com. Welcome to the show, Burt.
Thank you very much, sir, for having me.
Certainly. Well, we're going to cover the subject we were going to cover last week, but of course we always get into these, discussions, and time goes by so quick. So we're going to talk today about habeas corpus. Habeas corpus. Habeas corpus. Now, habeas corpus, it's a very important concept. One of the most important things I think there is in law. And yet we see again, let's be realistic here for before we start off. Habeas corpus is defined in Bouvier's 1856 as says a writ. It's a remedy. A writ of habeas corpus is an order in writing signed by a judge who grants the same and sealed with the seal of the court. That he is a judge, issued in the name of the sovereign power where it is granted by such a court or judge thereof, having lawful authority to issue the same, directed to anyone having a person in his custody or under his restraint. Anyone. It could be the President of the United States. That's fine. Commanding him to produce such person at a certain time and place, and to state the reasons why he is held in custody or under restraint. Now, the Constitution of the United States, of course, as we've discussed so often, provides the writ of habeas corpus, and don't make the mistake of thinking it's anything else but a privilege. It says very specifically, the privilege of the writ of habeas corpus shall not be suspended unless, always with the exception clauses, unless when in cases of rebellion or invasion the public safety may require it, and the same principle is contained in many of the state constitutions. One of the important parts of this is it goes on, and it says, the writ may be served by any free person. The person to whom the writ is addressed or directed is required to make a return to it within the time prescribed. He either complies or he does not. If he does comply, he must positively answer. It is a demand. It must be answered. It cannot just be ignored. Whether he has or has not in his power or custody the person to be set at liberty, or whether that person is confined by him, if he returned that, he has not had him in his power or custody, and the return is true, it is evidence that a mistake was made in issuing the writ. If the return is false, he is liable to a penalty and other punishment for making such a false return. If he return that he has such person in custody, then he must show by his return further by what authority and for what cause he arrested or detained that person. If he does not comply, he is to be considered in contempt of the court under whose seal the writ has been issued and liable to severe penalty to be recovered by the party aggrieved. That's a very powerful writ. Would you not agree there, Burt?
Yes, and here's the point that people need to keep in mind. The habeas corpus, and of course we're talking about the habeas corpus ad subsidium. I think that's how you pronounce it. It's actually a writ to maintain peace. Peace between nations. If an agent or a representative of nation A is captured by nation B and thrown into the cellars of that whatever prison or whatever, the other country gets to issue a habeas corpus ad subsidium. And this allows that particular prisoner to be taken out, and if the reason for being held is not, cannot be substantiated, then he needs to be returned to his nation, and peace is maintained. So this is actually a way to prevent war.
It's under the international or the law of nations is the point.
Yes.
And the United States and every other nation out there, it's one of the bizarre concepts that people need to understand is that it's a requirement to be under the law of nations to even consider yourself a nation. This is again why the United States would not consider or did not consider the Confederacy in the Civil War a nation, because if it would have admitted legally and lawfully that the Confederacy was an actual new nation, and it was, but they didn't acknowledge it, never gave them that right or privilege, they would have had to do things a lot differently. They wouldn't have been able to kill people like they did. They wouldn't have been able to force things upon that nation. It would have been a defeated nation, and it would have required a lot of these things like habeas corpus. So by not recognizing, and that's according to the government itself, they never did recognize the Confederacy as a new nation. That whole all those states that supposedly seceded lawfully, they had no rights. They were still part of the United States because they were not recognized as a nation. If they were a nation, everything would have been completely different.
Yeah, the whole picture changes. And here's the point that people really need to, and that's why I keep saying that we cannot be completely in revolt against the law, because the same law that they are trying to apply to us is the same law that they would apply to someone from another nation. So the law must maintain a certain degree of integrity in order to maintain international relations.
Okay. Did you find out where that integrity is around here? I haven't seen it lately.
Well, it's a fact of international relationship. Now, what happens between the different governments is they turn a blind eye to certain things that certain nations are doing in order to maintain, another part of the relationship alive. But overall, when you mix all the different nations together, there has to be a minimum degree of integrity. Otherwise, international cooperation cannot exist. Otherwise, you have thieves dealing with each other who don't trust each other, which means that then they're always in war with each other. So in order to maintain peace, there has to be a certain degree of integrity.
So basically what you're referring to is what we call honor among thieves.
Yes.
the nations. It's a bizarre concept, but very important to the concept that we have any quote-unquote freedoms at all. I mean, really.
Yes. And the whole idea of this whole thing is that there are venues within their system for us to get our, maintain ourselves free. And, when we come back after the break, we can get into the very obvious thing, which is the difference in cost of a habeas corpus and a statutory appeal.
Absolutely.
So obvious.
All right, folks, stay tuned. We'll be back.
First of all, let me take just a moment to thank you for allowing me back into your homes. If this is your first time with us, let me extend a personal invitation.
Let's build a happy little cloud. Let's build some happy little trees. There are no limits here. You start out by believing here. This is your world. You're the creator. Find freedom on this canvas. Believe that you can do it. Because you can do it.
All right, folks, welcome back.
Let it flow. Think like water.
You're in the corporation nation. Now, it's important to note that this, of course, habeas corpus has been utilized a lot. It's in many, many court cases. One of those cases, United States versus Booker, 543 U.S. 220. It says, quote, "It has been settled throughout our history that the Constitution protects every criminal defendant against conviction except upon proof beyond a reasonable doubt of every fact necessary to constitute the crime which he is charged." In a different case, which I won't read, which was 1970, it is equally clear that the Constitution gives a criminal defendant the right to demand that a jury find him guilty of all the elements of a crime with which he is charged. Now, Burt, you were talking about the price or the fee, if you will, to the difference between what it costs to do an appeal, which is why attorneys always and courts always want you to appeal a case as opposed to doing an habeas corpus, which, of course, when you're talking about after you're already convicted, and you know that they haven't successfully proven that shown all the elements of the crime, or that there's a doubt as to the just cause and the evidence. Well, yeah, are you going to appeal it, or are you going to do a habeas corpus?
Yeah, well, the very first obvious thing that should be able to be seen by the people, like the sun coming up on the horizon, is the fact that the habeas corpus cost $5 to file, and an appeal typically is over $500. Big difference. So you may want to ask, why is one $5? Why is the other one $500? Because the one of $5 is a right to have. International right.
It's you broke up there. What is it?
It's an international right.
Ah, okay.
And the other one is a privilege. Your right to appeal is a privilege. Now, earlier you mentioned that the Constitution allows the suspension of the habeas corpus. Actually, the Supreme Court says that Congress does not have the right to stop a habeas corpus.
Well, and the other aspect is, if you get a habeas corpus, you're required to respond and hold that in legal terms. Whereas an appeal, they can say, nah, no appeal for you.
Yeah, the habeas corpus, anyone who presents a habeas corpus, it has to be answered. Congress cannot stop habeas corpus ad subsendium from answered.
Well, now the excuse could be used, of course, because we've talked before about the Lieber Code and all that stuff. The fact that courts are basically churches and militarily executive churches, really. So the argument could be made that, well, you could deny habeas corpus on the fact that the case in itself is, as the Constitution says, a threat to quote-unquote national security, a threat to but really, most cases are not in that arena. It's very rare to have that type of case. When you're talking about a typical, just the victimless crimes that happen every day in court that put people in jail, mostly because they want work for, cheap labor force. That's where we're talking about here. Because they have no issue. There's no way they could say, well, this guy smoking pot over here or growing pot plants is a threat to national security. It would just be a frivolous argument.
Well, but what people have to always keep in mind is that a criminal crime, which is basically where the habeas corpus ad suspendum would come in, it's a political violation. A political violation does not necessarily mean that you violated any specific man or woman. You just violated some statutory legislative act. So there's a huge difference there. So the type of habeas corpus that we're talking about is where a political violation was supposedly executed by the one that's in jail, and because it's political and there was no man or woman actually injured, that's actually really easy to deal with.
Yeah. Yeah. So $5, huh?
Well, I mean, what a difference.
That's like, hey, everybody, over in aisle 2, we have habeas corpus on sale for $5 today. Get it while it lasts.
Yeah, but now here's a huge point, and this is a big mistake that happens with people that enter habeas corpus. Now, the purpose of the habeas corpus ad suspendum is basically for you to be brought to the proper court, for you to be taken out of one nation into the other. Now, if you are in jail and you have no support besides yourself, you're kind of screwed. The habeas corpus ab suspendum is not going to help you.
In other words, you can't issue it for yourself.
No, when you attempt to issue this habeas corpus, the federal courts or the state courts will read it as a motion. And that's not what the habeas corpus is supposed to be. A habeas corpus is not a motion to the court related to the case.
Well, then what does it fall under? Is it would it be a demand? Would it be technically? I mean, if it's a required action, what would we technically call it then?
Well, I don't know what you would call it, because this particular habeas corpus has existed since before the United States was ever created.
And that's important in and of itself, too, because when something existed before the United States, that means that, the creator of something can change something, but when it exists before the creator exists, that gets a little hairy. It's a little tough for a nation to change fundamental maxims of law.
Yeah, well, the legislature, and when you said the word nation, you're referring to the legislature. Now, the big difference here that I'm trying to get at is that when you are inside of the jail and you issue your own habeas corpus, the courts will read it as a motion connected to your case. Mm-hmm. And anyone who's been involved in court, you know that a motion is just a motion to move the court. Now, when it is entered from outside of the court, now it can only be read as what it is supposed to be, which is a habeas corpus ad suspendum. It cannot be read as a motion.
So really, it's an activist type of thing. It said any person can issue on behalf of another person.
Yeah. Now,
well, imagine
a lot of attorneys make the huge mistake of using the habeas corpus as a motion. Also,
well,
the attorneys screw it up themselves.
I don't know if it's a mistake or not.
Well, I don't know.
I think a lot of those mistakes, quote unquote, are not mistakes, actually. Mm-hmm. Mm-hmm. Imagine, folks. Just imagine. I mean, let's say you've been in jail 10 years. You can still file a habeas corpus on behalf of somebody. I mean, there's no statutes of limitations to provide evidence of, think of how many people we can get out of jail if we were somehow to be able to organize with this. Anyway, we'll be back, folks. Stay tuned.
He's a rebel and a runner. He's a signal turning green. He's a restless young romantic, wants to run the big machine. He's got a problem with his poisons, but we'll find it.
habeas corpus, better known or lesser known as habeas corpus ad subjiciendum, defined as a writ directed to the person detaining another and commanding him to produce the body of the prisoner or person detained. This is the most common form of habeas corpus writ, the purpose of which is to test the legality of the detention or imprisonment, not whether he is guilty or innocent. This is a very important distinction. Okay, the legality of the detention or imprisonment, not the guilt or innocence. This writ is guaranteed by the U.S. Constitution, Article 1, Section 9, and by state constitutions. 28 U.S. Code, Section 2241, also includes that. Now, we also have to remember that this is part of the common law. This is the well-known remedy in England and the United States for deliverance from illegal confinement, of which Sir William Blackstone, a very important historical figure, often quoted in legal dictionaries, called it the most celebrated writ in the English law. They even call it the Great Writ of Liberty. And the great officiosus, I'm not going to say that word, writ in all matter of illegal confinement. The Great Writ of Liberty, issuing at common law out of courts of chancery, King's Bench, common pleas, and executure. King's Bench is a very important concept, too. I don't know if you're familiar with that, Burt. Unfortunately, it's not here. We have something similar that I can't remember the name of. But King's Bench is like basically calling the Queen to court in England, and not enough people know about that. But we'll talk about that some other time. But I mean, this is a very important concept because again, you're doing this on behalf of someone else. And there's no reason you can't do it on behalf of someone you don't know. I mean, for God's sake, how many people are in prison for absolutely worthless reasons, absolute tyrannical reasons, again, just for slave labor? To test the legality of detention or imprisonment, not the guilt or innocence.
Yeah, now here's the funny thing about the habeas corpus ad subsendium is that you can employ it in a criminal case, right? But it follows civil procedure. So you're actually bringing in the habeas corpus and you are taking the criminal case, which operates under supposedly criminal proceedings. Now you're moving the whole thing over into civil proceedings. And how do you win a habeas corpus? By preponderance of the evidence.
Oh, my goodness. There you are doing it again, man. Not the evidence. Jeez. My God, we're going to look at the evidence, really? I think that's against the church, isn't it?
Well, but here's the thing, and here's where it gets really confusing for people, is that you cannot re-argue the evidence. The evidence is the evidence. You're not there at this particular hearing to argue whether it is black or whether it is white. That doesn't matter. What matters is if the principle of law that was applied in your case was right or wrong.
Well, there again, that U.S. Code that we referred to, 28 U.S. Code, subsection 2241, says very clearly, the writ of habeas corpus shall not extend to a prisoner unless he is in custody under or by color of the authority of the United States or is committed for trial before some court thereof. So when we're talking about, that is so important because almost everything that this government does to us is under color of authority. That's the illusion of authority. It's not real authority. And it's actually punishable by law, by 1 or 10 years in prison to act under color of law.
Well, but the thing where people get confused about color of law, just calling something color of law doesn't make it wrong. Okay? What makes color of law wrong is if someone approaches you attempting to exercise color of law on you, even after you tell them no.
Well, and there again, it has no weight or authority unless you actually issue it into a court and say you're acting under color of law. Otherwise, they can color all they want to. They can color way outside of the lines because nobody's actually accusing anybody of acting under color of authority. It's never an official accusation, just, grumble, 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 grumble. That poor farmer out there in Nevada. They're stealing his cattle and surrounding his home under color of law. Grumble, 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 grumble. But no one actually puts a writ in or a complaint or a demand or a lawsuit of any type. That's really what the problem is. Because, color of law exists. It's all over the place. Every time you're pulled over by a police officer, no one ever does anything about it.
Well, let me give you a perfect example of color of law. If you walked into Walmart, and I love using Walmart, and they tell you no one can come into our store today wearing a yellow shirt. You happen to be wearing a yellow shirt. They say, sir, I need you to take your shirt off, and I'm going to give you this blue shirt for you to wear today. You take off your yellow shirt, and you put on the blue shirt, and you walk through the store, finish your shopping, and then you leave. Then you file a lawsuit against Walmart for operating under color of law. Guess what? You have no case against Walmart. Why? Because you operated within their color of law. You took the yellow shirt off and you put on their blue shirt. There was no violation.
Participation into the fraud is, that's, again, going back to the maxims of law. Hey, buyer beware. Sorry.
Yeah. So how would you turn that against them? Would be when you enter the store, you say, no, sir, I am not bound by your Walmart regulations. I will not accept your color of law. Now, if they force you, now you have a case against them.
I can't remember Carl Lentz, his approach is, it's kind of funny when he talks about it. He says, everything that a cop or anyone asks him, he says, is that an order?
Mm-hmm.
Yeah, it's an order. Oh, okay, I'll do it. Next, is that an order? I'm going to, get out of the car. Is that an order? Give me your license. Is that an order? Well, guess what? If they're giving you an order, that's color of law. It's no longer a voluntary process. So he's trapping them, literally. It's brilliant.
Mm-hmm. Yeah, but you have to be aware of what is happening, because if you are ordered to do something under color of law, and you don't make it clear that your consent is not part of the action, then you have no remedy. So in order to maintain remedy, you must make it clear that your consent is not part of the interaction.
Yeah.
And that's a huge concept for people to digest, because people very often accept the benefit, and then when they don't like the benefit, they go back and complain about it and try to sue.
Well, and that's the trick, you see, because when we hear words like benefit and right and all, we think, oh, those are all good things. Good things. Benefits are good things. No, unfortunately, there is no emotion. There is no good or evil when it comes to the word benefit. It's your benefit. Remember, my favorite U.S. code, I'm going to pull it up and read it again, and I'm going to read it over and over until this sinks into people's head. Let me pull it up, because this is your benefits, okay? Equal rights under the law. Now, we talked about the difference between equity and equality, completely different aspects. One is under natural law or in harmony with natural law. That's equity. Equality is the complete opposite of that. What does it say? Okay, folks, this is America. Nothing else says America or made in America like Title 42 U.S. Code, subsection 1981. Equal rights under the law. Statement of equal rights. Section A, Statement of Equal Rights. All persons within the jurisdictions of the United States shall have the same right in every state and territory to make and enforce contracts. Very important, because that's how, of course, the the benefits are placed into you, the duties, to sue, be parties, give evidence, and to the full and equal benefit of all laws and proceedings for the security of persons and property, as is enjoyed by white citizens. Yeah, in other words, we all got made into slaves. We didn't elevate the blacks, we de-elevated the whites. But see, it goes on. All persons within the jurisdiction of the United States shall be subject to like punishment, pains, penalties, taxes, licenses, and exactions of every kind and to no other. We've talked about this before. What is exaction? Exaction literally translates to extortion in the legal dictionaries. Folks, you are subject as a benefit by being a citizen to punishment, pain, penalties, taxes, license, and exactions or extortion of every kind. That's your typical police stop, folks. My favorite of all U.S. codes right there. We'll be back.
We've already stripped you of your liberty, privacy, civil rights, and dignity. You want some more?
Scientists have been battling to understand what this unappealing object is all about. What the object is all about.
Information in the form of energy streams in simultaneously through all of our sensory systems in the form of energy. And then it explodes into this enormous collage of what this present moment looks like, what it feels like, and what it sounds
all right,
like. Explodes into this enormous
welcome back. You know, let's take a current example of how this works. Now, again, all persons are subject to their benefits as punishment, pain, penalties, taxes, license, and exactions of every kind and to no other. But you see, it goes on. It tells you what making contracts. But Section C is very important. And this goes out to Mr. Bundy, whose farm is being assaulted right now, whose cattle are being taken apparently under eminent domain with no just compensation. So let's read what it says. Folks, listen to this very carefully. For those of you who still believe in this mythological states' rights thing, and they don't exist. Here's what it says. The rights protected by this section are protected against impairment by non-governmental discrimination and impairment under color of state law. The federal government here is saying that no state law will ever trump its own. They are actually saying here that all state law, when compared to federal law, is only color of law. If you don't like your punishment, pain, penalties, taxes, licenses, and exaction, which is exactly what's happened to Mr. Bundy out in Nevada right now, well, guess what? You cannot go and get the state to do anything for you because federal law trumps state law. I'm sorry to have to be the one to tell folks this. It's not a pleasant thing to admit or to realize. It's just true. Article 6 of the U.S. Constitution, very clear. Even a child can understand the federal law trumps state law. It's right there in the Constitution when they are in conflict. This is why the feds come in and bust all these people with marijuana, legal state-run or state-permitted marijuana. It's federal law trumps state law. The Constitution also makes it clear that federal courts, not state or local courts, may rule on the constitutionality of laws and statutes. Local courts have nothing to do with the Constitution. They cannot say what is constitutional or not. Quit expecting them to. Okay? The legal ownership of land, everybody should read the Gadsden Purchase of 1853, basically giving the federal government clear title. Okay, title. Artificial, yes, but still title to the BLM land. They are the managers of that land. They have the title. And that's in every court ruling that you're going to see. It's we have to get this through our heads. We are ruled by a very small area called Washington, D.C. That is government. State governments really have nothing. Okay, federal law is always going to trump state law. That is fact. It is fact in the courts. It's unfortunate, but true. So the concept of states' rights, folks, forget it. I'm telling you. Your problem here should be with the Constitution. It should be with quote-unquote democracy. It should be with government itself. But, of course, what's happening out there is the farmer, Mr. Bundy, is trying to fight it within the system. It's not going to work. And they're going to take his cattle, and they're going to kill his cattle, and they're going to sell the cattle to other people. And unfortunately, those farmers out there, those ranchers, are no better than the cattle thieves of yesterday, because they're not going to stand up for the rights of this farmer. They're going to go to government auction, and they're going to say, yippee, here's some cattle for cheap, because they're stolen cattle. It's just legal for government to steal them, you see. If it were one of them trying to steal his cattle and sell them at market, well, they'd be arrested, of course, as cattle thieves. But government, they can do it. They can take your house. They can take your property. They can take your children. You see, this is the underlying problem. Forget the state. The state is basically a worthless ball of crap. It does nothing. There are no states' rights. I'm sorry. I don't mean to rant, but I'm so tired of hearing about states' rights and, let's appeal to the state. No. I'm sorry, especially when you're talking about a federal agency. There's no appealing to the state. What do you think, Burt?
Well, I mean, I'm partially there with what you're saying, but still, the system is a system. And, I mean, talking about this particular case that you're talking about, this guy Bundy, his problem is that he's basically barking up the wrong tree. Yeah. He's barking up the federal tree when he really should be barking up the state tree. Because although some of the things that you're saying are true, it still comes down to the reality that the federal government is in fact managing a piece of land within a territory of the state, and that can only happen with the permission of the state. So, in fact, the state can come to the rescue of this gentleman Bundy against the federal government. But the state, of course, is not going to do that, especially if Mr. Bundy continues to aim his guns at the feds. And then the state is just going to sit back and say, well, he didn't ask for our help, so we can't help him.
Well, if you say so, I obviously we're in disagreement here. Because the courts in the states are acting as federal courts. The only courts in the states that aren't are your municipal courts, which are basically just private commercial courts.
Well, it's a yes and no thing. The feds can only manage. They don't actually own the land. They just manage it. They manage it for a federal interest, okay? And that management cannot happen without the consent of the state. And remember, the legislature supposedly represents the people.
Yeah, but they already have the management. They already have the title. They already have the state's acquiescence. So the state can't renege on its already given consent. I mean, the crime is the so-called federal crime is already happening on so-called federally managed land. The state has nothing to do with it, unfortunately. I mean, we can agree to disagree here, but I mean, I'd ask you to probably show proof that the state can do anything.
Well, what we would have to do is we'd have to find those agreements that granted the management rights to the feds, and that's what we would have to begin from there and then go forward.
Well, we can maybe we should try to help this guy out. I mean, for God's sake. But well, yeah, all right. We'll keep that as a bone of contention, and maybe we'll solve it later on. But in my understanding, I mean, that there's no states' rights. It's total illusion.
Well, yeah, I mean, it gets complicated, but getting back to this habeas corpus thing, here's a way to kind of summarize how you can use the habeas corpus, because a lot of attorneys are misapplying it. And that is, the habeas corpus must concern itself with questions of law, which includes not only pure issues of statutory meaning or interpretation, but also application of law to undisputed facts. And that's where the facts become an element in the whole issue of the habeas corpus, which means that it will support your position, but you're not necessarily challenging the facts. And that's the point that is different.
Well, and there again, you're not talking about guilt or innocence, because, I mean, to be guilty of something really doesn't mean anything if that something is not a valid thing. In other words, it's a colorful thing. It's not something deserving of the full penalty of law. So, I mean, again, it's now the question is, when the habeas corpus is presented, and it has to be answered, the question becomes, what happens if the habeas corpus is acknowledged and the charges are found to be, inexacting? And now, is the person let go until a new trial can be held, or is that where the appeal process comes in?
Well, we'll deal with that when we come back then.
Okay, well, you remember, because I'm getting old, my memory's going.
Me too.
Stay tuned, folks. We'll be back.
Soldiers, don't give yourselves to brutes. Men who despise you, enslave you, tell you what to do, what to think, and what to feel. Who drill you, diet you, treat you like cattle. Don't give yourselves to these unnatural men. Machine men with machine minds and machine hearts. You are not machines, you are men. You, the people, have the power to make this life free and beautiful. Let us use that power to make this life a wonderful adventure. Let us all unite. Let us fight for a new world to do away with greed. A world where science and progress will lead to all men's happiness. Do not despair. The hate of men will pass and dictators die. And the power they took from the people will return to the people. Let us all unite.
Welcome back, folks, to the Corporation Nation. My guest today, Burt from Colorado. OnlyFreemen.com. Again, Burt does some really fantastic seminars. You might be very interested and get a lot of good feedback from the listeners. So, yeah, join up and check it out. I was just reading the comments in our chat room. Our chat room is corporationnation.chatango.com. That's CHATANGO.com. Corporation Nation. The people who went out and supported the Bundys out there in Nevada, they're getting tasered. Yeah, that's right. The federal agents are tasering the people who are holding up signs in protest to their illegal actions. What a surprise. Apparently, there was a huge oil find on and around the Bundy Ranch. And apparently, I have not verified this, but apparently there's billions in natural gas to be made fracking the area. So, I wonder what the real issue is here. Do you suppose, why this particular rancher? I don't know. It's the same story over and over and over. It's pretty pathetic, if you ask me. And I want to give my, I want to share my appreciation and my heartfelt gratitude for those people who are suffering by trying to, of course, tell these horrible agents of the government that they don't support what they're doing in their name. Unbelievable. Well, Burt, so, we're talking about habeas corpus today. Again, after you pay your $5 fee and you present the habeas corpus, which, by the way, has to be answered, cannot be ignored. Let's say that, okay, the habeas corpus is granted and the finding is that this person shouldn't be in jail. Are they taken out of jail just then? Because that is what the habeas corpus is asking or requesting or demanding. And then what is the process after that? Because I'm sure the state is not very happy about losing one of its subjects, one of its imprisoned, workers. So what's the process once this is? Well, I mean, let's start with, okay, you're in the trial, the habeas corpus quote unquote trial. What happens now?
Well, I mean, if you persist and basically win, then the judge issues the writ for you to be set free.
Now, is this a jury or a judge?
Oh, no, it's all before a judge. So
the judge can say no.
Oh yeah, of course. The judge can say no. But if it is granted to you, and of course, remember the whole key here is that it has to be based on law. Okay, not on some Martian belief or Jupiter belief. It has to be something very earthly, and of course the best law to go on is their law, because if they're violating their own law, they have to set you free. And what I am further searching into the habeas corpus is that, just kind of think about it logically. If you were, let's say, for example, an ambassador or something from another country, and you were here, and you were thrown in prison unlawfully, and you lost, let's say, millions of dollars due to the injustice that was done to you, do you not think they actually also have to put you whole again?
Well, I mean, if you were to ask me, I would say no, because it's a lawless system. But you're trying to actually, make their law stand against them. The question is, what is it that would is this a thing that a judge would not want to mess with? In other words, is there some repercussion if that judge, it's obvious that the habeas corpus should be granted, and he says, well, I am the all-seeing, all-powerful, judicial officer, and I say no. I mean, is there some crime and punishment there?
Well, the habeas corpus theoretically can move all the way up to the international court. So you can appeal it all the way to the U.S. Supreme Court, and you can go beyond that. Because the habeas corpus is supposed to prevent international misconduct.
Well, sounds like we should be filing habeas corpus for everybody in Guantanamo Bay.
Well, and actually the Guantanamo Bay is a good example because Congress attempted to make it look like the people in Guantanamo Bay could not benefit from the habeas corpus. And the Supreme Court said, no, you cannot do that. They also enjoy the benefit of the habeas corpus. Now, the problem with a lot of those people in Guantanamo is that the attorneys that have been representing them have been bringing in the habeas corpus under all kinds of crazy ideas that are beyond exactly what the habeas corpus, is about. So, to give people a better example of what we're talking about, we can concentrate on this particular case in which I'm presenting this habeas corpus in.
All right. Well, let's say that, okay, a judge says, yes, you're right. Habeas corpus is a necessary writ in this case. What is the process at that point? Obviously, if he says no, you'd have to appeal it and go and take it to the to the next court. But if he says yes, then what?
Well, whoever is holding you they have to set you free. They're giving a certain number of days to set you free, and it's a matter of days.
But then,
not months, not years.
Does that actually nullify the previous case, or do we have to go retry the case?
No, the case cannot be tried. If you were set free, that's it. It's over as far as the other case.
So that would be a case of double jeopardy, pretty much.
Well, it doesn't really apply. It just means that you're being set free because the case that was conducted against you was unlawful. So they cannot bring that same case against you again. I mean, that's the whole purpose of the habeas corpus, and that's why they don't like for you to bring a habeas corpus, because if it's granted, then it means that the prosecution that was conducted against you was unlawful.
Well, that's the biggest problem I have with it. And then, now, if I was a caller, I would play devil's advocate right now, and I would say, well, how many of these actually go through? Because you're talking about a secret society, not so secret, but a society of attorneys who protect one another as Masons. So how many of these actually go through?
Well, and actually, I mean, I've been reading a lot of these cases involving this. Of course, my point is going to be unscientific at this point, but I'm going to say right now it appears to be maybe 1 in 20 or less.
All right. Well, we'll get more into this when we get back from the break. Stay tuned, folks.
Is this real, or is this just a ride? The world is like a ride. You think it's real, it's just a ride. We can change it anytime we want. It's only a choice between fear and love. The world is like a ride. You think it's real, it's just a ride. We can change it anytime we want. It's only a choice between fear and love. Life goes up and down, round and round.
All right, folks, welcome back. Thrills and chills, and it's very brightly colored. Now, Burt, again, this concept that your typical judge is going to view and deliberate a habeas corpus request. It's problematic, unfortunately, to think that you're going to get a quote-unquote fair and impartial judge, don't you think?
Well, of course, you know. I mean,
so that's why
that problem.
Well, that's why I ask, what is the I mean, because, you know, for the most part, politicians, judges, attorneys, corporations do things because there's really no there's either no law to say they're doing anything wrong, or there is a law that says it's perfectly legal to do what they're doing. So what is the I almost feel like you have to threaten or somehow make the judge himself know that if he doesn't apply, you know, the rules of his own law, that there's going to be a consequence. Because for the most part, there's no consequence for these people. So what is the consequence, I guess, is the question.
Well, I mean, there are, you know, rules that govern the behavior of the judge. And, of course, that's another tool in the arsenal that we can use against them, that we can employ. I, at this particular moment, don't have a good grip on that aspect of it. The only thing that I can rely at this particular moment is the fact that the judge is supposed to follow their law. And if he doesn't follow the law, which is basically the intent of Congress, and that law that has already been predefined by higher courts, then that judge is actually risking putting his career on the line.
Now, would this be a good example where you could get your friends together or form form an activist group or a helper group that would sit in the court, and you could let the judge know that there's more than 3 people here who are more than willing to make a complaint against that judge, and for not acting, in proper uniform, if you will, because of course, we talked about this before. I don't know. I've never really followed up on it, but the fact that people don't actually complain about what their judges do in courts really is what allows them to continue to doing it. But if they suddenly receive official complaints, then isn't there, aren't they basically suspended until the complaints can be admonished?
Well, I don't know about suspended, but it's definitely all goes into the record. And just from my own personal experience with dealing with people, believe me, it makes a big difference if you show up to court by yourself or if you show up to court with 30 to 50 people. It makes a huge difference. Huge difference. And, of course, if you show up to court and don't, know very well what you are doing, of course, that makes a big difference, too. But having a huge group of people there and that group of people making it known that they're there supporting you,
as
it's
witnesses.
huge.
As
it's
witnesses,
huge.
yeah.
Yes.
Well,
so we need to come together is the point.
Yeah, that's always the end result of all these conversations. We need to support one another in this. Anything else you want to say? I mean, we could talk about one of your current cases. We won't name any names, but you do have a case that's going on where you've written, it's like a 40-page writ, basically, demanding of the habeas corpus. It has to do with marijuana laws, and the fact that the case is actually really ridiculous. I don't know how much you want to get into that, but maybe you could use that as another example of, because again, you're not just talking about it, you're walking the walk, which is why I have you here, and trying to actually help people. Someone who is in jail right now on basically trumped up charges that have nothing to do with the law. So I don't know how much you want to talk about that.
Well, I mean, this is a typical so-called marijuana case where someone goes to jail under the assumption and presumption that you can actually grow a controlled substance. I mean, how many people can take a couple of aspirins, bury them 3 inches, and come back next spring and have aspirin plants? It's impossible. But yet, that's the kind of insanity that goes on in court. But the point that people really need to comprehend is that in these courts, especially these lower courts, like the district courts, which are basically the bottom of the barrel, in these courts, there is no real justice that goes on. The statute or the code is never presented to the jury. What is presented to the jury is an interpretation of the statute, which is arrived at between the prosecutor and the judge. That's what is presented to the jury. So the jury never convicts you on the law. They convict you on the understanding, interpretation of the law that is arrived at by the prosecutor and the judge.
And this is why you say juries are so dangerous, because one, they're there without any knowledge of the law. Two, they aren't presented necessarily with the law, and if they are, they probably won't understand the language.
Well, and that's why they don't want the jury to see the law.
Yeah.
There's no one would be convicted if the jury was given the section, chapter, and title to review prior to convicting you. It would take them about 3 years to comprehend what's in there.
Yeah.
They would never convict anyone. So they give the jury a trumped-up, simplistic approach. And remember, a jury only convicts you on the facts, not on the law.
And yet, when they present the case to both, the state versus you, and they send you a case, it specifically lays out those laws that are being violated. And yet, again, those somehow never make it necessarily to the jury to actually see, is he actually breaking the code or the law? no, we're just listening to a bunch of clever attorneys use fallacy and ad hominem and appeals to authority and appeals to pity and appeals to, all these different fallacies, basically, to make a case that has nothing to do with the law.
Exactly. So in this particular case, what we are doing is we're telling the court, hey, this man was convicted on a misinterpretation of the intent of Congress.
And a purposeful one at that.
Yeah, I mean, if you study the transcription of what actually went on in this case, it's a joke. I mean, it's really, truly a joke. It's a kangaroo court. Well, and this seems like something out of a movie when you tell people that there are actually kangaroo courts, and it's actually a legal term, kangaroo courts. And that's what the lower courts actually operate under.
One of the interesting parts about this case was one of the actual claims, which was really interesting because the jury actually said, I'm trying to find it actually. It's very funny actually, because they said that the law that was broken was either or. We'll have to find that. We'll have to find that and read it, because it's so funny to actually hear, well, this person broke this law or that law, is basically what it says. And you're like, what? How can that be? So stay tuned, folks. We'll be back.
Living in the street. Oh, there's a solution.
Hi, neighbor. Welcome again to this neighborhood. I'd like to show you something. You know what this is? Well, maybe if I press this button. There are so many things to learn about in this world, and so many people who can help us learn, and so many people who can help us learn. Did you ever grow anything in the garden of your mind? In the garden of your mind. You can grow ideas in the garden of your mind. In the garden of your mind. It's good to be curious about many things. You can think about things and make believe. All you have to do is think. You can think about things and make believe. All you have to do is think, and they'll grow.
All right, folks, welcome back. So, in this case, this habeas corpus ad subjiciendum, it says... This is what the jury actually said, which is the most ridiculous thing. I can't believe they actually let this go. Count number 2. Manufacture or possession of marijuana with intent to distribute. Now, remember, this is I believe this is a person who actually has a license to grow marijuana. We, the jury, this is what the jury said, and this is how idiotic this whole thing is. We, the jury, in the above-mentioned case, unanimously find this person, name withheld, guilty of manufacture or possession. Manufacture or possession with the intent to distribute marijuana. I mean, do you see how ridiculous that is, folks? I mean, we find that you're guilty of this or this. Well, that's not a charge. What does this mean, Bert?
It's not even a decision.
No.
And here's the problem with this. Now, we hear Clint constantly make the point that language is everything. Now, in this particular situation, that cannot be, I cannot emphasize, the message that Clint tries to get across for people to comprehend the language more than this. Because, in fact, the word or does not always mean what we think it means in everyday language. Legally speaking, the word or can also mean and. Okay? That's how crazy the legal language is. But, there's a big but. And in dealing in legal language, we must always understand the buts. And the buts are the huge tools that we can use for our advantage. The word or can only mean the word and when it is used either by the legislature or by the court. But in this case, the word or is being used by who? By the jury. Which means that the word or can only have one meaning, and that is the generally understood common meaning. But no one ever catches on to any of this stuff. And the attorneys, of course, that are supposed to be protecting your interests, somehow play deaf to this very simple terminology, which is mind-boggling.
Well, now, one of the comments says that the word or is generally in federal law considered and. So, but the way it's written in this case, I don't see how you could say or and have it mean and. It's just ignorance is what it looks like.
Well, and, that's what I'm trying to say is that when the jury speaks in common language. The jury does not speak in legalese. The court and the legislature speak in legalese, not the jury. So here, the court would have to make a case that the jury, in fact, meant and instead of or. And I've already conducted my own survey and asked, several people, does the word or and the word and mean the same thing? I haven't found one single common man to say, yes, they mean the same thing.
Yeah, and like you say, it's all in the words. And that basically, that means to me, and obviously to you, and in your claim here, that means really, again, let me read this again. Manufacture or possession of marijuana with intent to distribute. We, the jury, in the above-mentioned case, unanimously find him guilty of manufacture or possession with the intent to distribute. That's not a decision. That's not a verdict. It's a
proposition.
It's something else. Yeah, it's strange. And the whole case is like this.
Yeah, well, and when you look at a lot of cases, and you look at the true language, and you look at actually what went on in the court, you come to realize that the man or woman wasn't convicted of what you thought he was convicted on. In fact, very often they're not convicted of anything.
Yeah. It's incredible, and it's funny that, when you started saying this about you're starting to realize how dangerous it is to put yourself in and to demand a jury trial. I'm starting to see what you mean. I really am. Because
now earlier you said you were quoting from I think Bovier's, and you were saying that every man has the right to demand to have every element presented to him in front of a jury or something to that effect. If we really think about what you're saying when you repeat that to a court, you're saying, okay, you're accusing me of a fictional violation, and I demand that you bring me in front of this fictional jury so that I can be at risk of losing my freedom. I demand that you do that. That's what you're actually saying.
Not to mention, you're talking about marijuana. We've talked about this before. It's very important. Marijuana is a legal fiction name that was created for cannabis sativa, and it literally requires you as a person to not necessarily admit, but to consent to the concept that your cannabis sativa, which is a real tangible plant, is in fact a legal fiction called marijuana, something that is in the artificial realm that doesn't actually exist.
Yeah, which is a controlled substance.
That's crazy. Why would anybody do that? But of course, this guy went and tried to do things reasonably and lawfully, and he went and got a permit to grow the fiction marijuana, And it backfired on him, you know.
Yeah, and saying this is what people need to realize. Every man or woman out there that has one of these licenses to grow, up to 10 plants, blah, 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 and medicinal marijuana, what you are admitting is that you are, in fact, possessing a controlled substance. And the federal government does not have to recognize the state's interpretation of how to control the controlled substance.
Yeah, and this applies basically to, this concept applies across the board, from your home to your children, to your guns, your arms, which you stupidly register as firearms, your house, you register it as a dwelling, as a residence, your children, you register them as something artificial, you're admitting to the state that your own children, your own home, your own property is all a legal fiction, which is just the stupidest thing we can do. But it is, of course, what we've all grown up to believe is the correct thing to do to be good little citizens. And it's so pathetic when you think about it.
Well, and that's why, I'm going to have to do an addendum now to that little booklet that I did about, cannabis sativa is not marijuana. It's not illegal. The plant is not illegal at all. But if we take this a step further, we come to realize that all these things related to controlled substance are all under the supervision of the Attorney General for the United States. And the Attorney General, believe it or not, is extremely limited on what he can do with that controlled substance list. He has no power to interpret the intent of Congress. And in fact, that's what he does in order to be able to prosecute you. So he is violating the very law that he's supposed to be enforcing.
Crazy stuff. I've invited, behind the scenes here, my good friend Hal Anthony from Behind the Woodshed. We had him on a couple weeks ago, actually. He's been talking about habeas corpus. We're trying to get him on the line, and he wanted to say a few things about his experience in habeas corpus and how you have to follow the letter of the law exactly in order to get it to do. And it does work. So when we get back, we'll hear from Hal. Stay tuned, folks.
Derivatives, quantitative easing, trade imbalances, recession, low GDP, nations close to collapsing, and subprime loans, foreclosed homes, and people's taxes spent to bail out too big to fail AAA banks again. Fear levels rising as the US crash seems imminent, having smashed the debt ceiling of 14 trillion. Despite protests and clashes in Athens streets, the IMF imposed structurally unjust programs in Greece, where in fact the term economy entered our language from the Greek oikonomia, meaning household management. Well, how are we managing? Theories abound, but in practice, does anyone actually know what the hell's even happening?
All right, folks, welcome back. Well, we were trying to get Hal on the line, but we're having some connection issues. What he was saying was basically, as he was listening, that when you write a habeas corpus correctly for a politically held prisoner, he will be released, and the habeas becomes moot. Will be heard, but you have to do it basically in the correct format. So there must be a specific procedure that must be followed. So there's probably a lot of extraneous stuff that you could include and be all righteous, but in fact, it's probably a more simple process. I'm sorry we can't seem to get him on, but we'll try again some other time, I guess. So, Burt, we're talking about we're basically talking about the concept that that this all relies on the concept that basically you're admitting to the legal fact that you are participating in a legal fraud, a legal fiction, and the law is thus based on the concept that the that the marijuana in question, marijuana being sort of a legal term that gets applied, you're admitting that that legal term actually applies to what you're growing, smoking, holding. But in fact, the important thing here is really that a plant in and of itself, growing under nature, under God, cannot, by definition, be a substance, because a substance must be what?
A substance has to be something man-made,
manufactured. It must be. It can't. You cannot grow, like you said with the aspirin. You cannot grow an aspirin tree, although the bark of a tree is what they make aspirin of. But if you have the whatever that tree is, I can't remember what it is. It's like a birch tree that the aspirin, the bark is made into aspirin. They can't say, "Oh, you have an aspirin tree," because the tree itself is not aspirin. Aspirin is made after the fact from something natural. So, in fact, a tree that produces the bark that makes aspirin cannot be a controlled substance. It's a plant.
Well, here's the thing that I try to get across to people, which seems to help get the point across. Imagine 2 or 3, scientists, crawling on their belly through the jungle. And they come across a little caterpillar, and the little caterpillar poops. And he takes a sample of the poop. And Lord and behold, this poop contains some kind of an enzyme or something in it that cures some kind of a disease. Well, what are we going to do? Have a caterpillar poop manufacturing, farm? We'll never be able to get enough poop out of those caterpillars to produce this drug.
Sounds like we're going to have a poop party.
Yeah.
I mean, unless it's made illegal.
Right. So what they have to do is they take it to the laboratory and they try to see if they can imitate it in the lab. And then they create an isomer of it. They create a mirror substance of it, and now they can mass produce it.
And they can limit it because it's a synthetically made.
Exactly.
Now, what is in your habeas corpus, and one of the things that you were arguing is that they're saying that the synthetic compound that is in all over throughout the plant. Well, actually, you're going to have to explain this one. It's a word I can't remember again, but that it's synthetic, and therefore it can't be part of the growing process.
Well, it's the THC. The THC in the plant is what they claim is the substance, or is the thing that makes the purpose of growing the marijuana plant. That's why people grow it, so they can get high off the THC, right?
But the THC that occurs naturally in the plant.
Yeah, the THC is organic. See, that's another term that people need to comprehend. There's organic and inorganic. Everything that happens naturally is organic. Everything that happens in the laboratory is inorganic. And the courts have already decided and made it clear that which is controlled by the Controlled Substance Act is that which is inorganic, which is the mirror image of that which occurs inside the plant naturally. And here's another point people don't realize. The THC only becomes separated from the other parts of the plant when you heat it up. So when you're smoking it, the heat separates the THC from the rest of the plant. It doesn't get separated naturally.
So, in other words, as long as it's not purposefully separated from the plant, again, there's no way you could consider it a substance unless first you take it out of the plant, and then even then it's not necessarily a substance. You have to actually mix it with something else for it to become a substance, right? A drug, if you will.
And that's the thing. A controlled substance, in order for it to apply to a plant. See, technically, marijuana you don't know what it is. Marijuana is something. We just don't know what it is. But what they want you to believe that it is that it is this part of this plant combined with a controlled substance. And then that becomes marijuana. So technically, you don't know what it is.
It's just a legal word. It's a word that was taken from the Spanish word, and which is in America is basically a slang word almost, and they've made it into a legal term that, again, they wish to put the wool over everybody's eyes, including the jury, that the word marijuana applies to a plant in its singular natural form, and that is what is against the law, when in fact marijuana, the term marijuana, does not actually refer, because the term marijuana is a drug, a substance, a whatever. So in other words, it's just a big lie.
Yeah, well, now that's if we're speaking federally. Federally, marijuana spelled with a J is actually a weed. The Department of Agriculture has, actually Congress has determined that marijuana spelled with a J is, in fact, a weed. Okay, so marijuana spelled with a J is not marijuana spelled with an H. Federally speaking, marijuana spelled with an H is, in fact, a controlled substance, whatever it is. We don't know what it is, but it's a controlled substance, whatever it is. But when you talk about the states all refer to marijuana spelled with a J. And in their statutes, they call marijuana spelled with a J a controlled substance. So now you combine that word with the federal statutes, and now you're caught completely, because it doesn't matter which way you spell the word, it's a controlled substance. And you're basically screwed.
You're screwed if it's proven and you're consenting to the fact that it's the controlled, it's marijuana. But and there's the underlying problem. Of course, we're just about out of time, Burt. But
yeah, the word you were looking for is tetrahydro cannabinols.
Yeah.
Tetrahydrocannabinols.
But that word is a synthetic, right?
Yeah.
So there's no way that could actually be in the plant.
No, there's no such thing as something. Yeah, the producer just put it there in the chat. Yeah, there's no way you can grow something synthetic naturally. Obviously, it has to be grown in the lab.
You know what this proves, don't you? That the producer is a stoner. Oh, producer. We're not going to say who's producing, but the fact that you knew that, no, I'm just kidding, man. Thanks for all you do there. Thanks for all you do while being stoned. No, just kidding. I'm kidding. All right, Burt. Well, I appreciate you being on here, man. Incredible stuff when you think about it, because God, the tyranny that goes on just because of words, like you said. OnlyFreemen.com. Check it out. Burt's doing some wonderful things and helping a lot of people. Thank you, Burt. We'll see you next week.
Thank you, bud. Take care.